appeal Beghal and the Director of Public Prosecutions.
Lord Hughes will give the judgment to the court.
Mrs. Beghal was stopped at the airport on her way back to this country where she lives. She was questioned by police officers under counter-terrorist powers. She wasn't under arrest and she wasn't taken to any police station, but there at the airport she was asked questions about herself, her family, nationality, where she'd been, who she was meeting, what her means were, and such matters. She refused to answer any questions. They let her go, but she was prosecuted in the magistrates' court for the refusal. The magistrates imposed a conditional discharge. By way of appeal, she has challenged the lawfulness of the statutory powers under which she was stopped and questioned. It wasn't suggested that the police either stretched or exceeded the powers given by the statute. They are specifically provided for in the Terrorism Act 2000. Under that statute, police officers can question people who are passing across British borders, usually at a port, and whether inwards or outwards. The questions which are allowed are by way of exploratory inquiry. They have to be geared to seeing whether the person appears to be concerned in any act or proposed act of terrorism. The traveller can be stopped and kept for the purpose of the questions. The police can require production of identity documents. They can inspect any other document which is being carried, and they can copy and retain the contents of electronic equipment. And the traveller can be searched. The power is, in practice, exercised only by specially trained police officers. The question in this case was whether it was lawful for Parliament to create those powers, or whether the statute is invalid because they unwarrantably infringe one or more of the fundamental human rights of the people who may be stopped. Specifically, do they unjustifiably infringe the right to liberty by amounting to unlawful detention, the right to respect for private and family life, and the privilege against self-incrimination. Articles 5, 8 and 6 of the European Convention on Human Rights, which are, of course, rights part of the domestic law throughout the United Kingdom through the Human Rights Act 1998. So the courts have the duty of deciding whether those rights have been unwarrantably overstepped. In reality, the main underlying question in this case has been whether this kind of questioning can only be permitted, even by statute, if the policeman already suspects that the person has been concerned in a terrorist act. That would mean, must he show either that he already has grounds which would justify arrest and lengthy detention, or that he can show in court that he actively suspected the person. Or is it lawful, in the interests of public safety, for Parliament to make it possible to question anyone who is passing in or out of the country in a preliminary or exploratory intelligence gathering way in order to find out whether he or she may be connected with terrorist acts. As it happens, it may or may not be that Mrs. Beghal's case would be caught even by a narrower power, because she did in fact, it seems, have a close family connection with somebody in custody for terrorist matters. But that hasn't been investigated. What the court has confronted is the wider and more fundamental question of whether Parliament could or could not lawfully create the power. The majority of the court holds that this questioning power is lawful. It's justified in the interests of counter-terrorism, defence of the realm, and the protection of public safety, and it is a proportionate and lawful response to the danger of terrorism, which Parliament was entitled to adopt. There are two judgments which reached this conclusion, one from myself, Lord Hodge agreeing, and the other from Lords Newburger and Dyson. Lord Kerr disagrees, taking the view that unless there is already a suspicion, there is a disproportionate interference with the rights which I've mentioned.